Intellectual property creation and management for emerging growth technology companies. International IP rights enforcement, ADR, and national enforcement. This presentation is brought to you by the IP attorneys and professionals at Hulsey Intellectual Property Lawyers through the Hulsey Intellectual Property Technology and Invention Monitor website. Hulsey Intellectual Property Lawyers, IP professionals for entrepreneurship's new golden age. This presentation is part of the Technology and Invention Monitor website's Legal and Business Issues and Instructions resource. Intellectual property creation and management for emerging growth technology companies. International IP rights enforcement, ADR, and national enforcement. Let's begin the presentation.
Fact is that both business and legal communities have come to realize that IP disputes are actually problems to be solved rather than contests to be won or lost. And with such a perspective, alternative means to resolve conflict become more appealing. There's a point in my career where I came to realize that in intellectual property rights, there's always a transaction, either, and particularly as it relates to the use of intellectual property rights, there's always a transaction. If someone wants to use my intellectual property rights, there's always a transaction. If you make reference to the Yale negotiation or the Harvard negotiation project, I forget which it is, there's the position in negotiation where there's the objective of establishing win-win agreements. You can have a win-lose agreement, you can have a lose-win agreement. The focus is having a win-win agreement or having no agreement whatsoever. In the adjudication, in the litigation of intellectual property rights, everything's a transaction. Either there's a negotiated license or there's an agreement not to use someone's intellectual property rights. If someone has used and infringed your intellectual property rights, you've got the choice as a right holder to pursue by either judicial or non-judicial means compensation for the use of those rights. If there's a compulsory licensing regime, which there's not in the United States, but if there is, where you have your intellectual property rights, you may be required to license, but for some form of compensation. You may seek for judicial, you may seek some type of non-judicial resolution of the infringing action. But at the end of the day, there is a transaction. If it's a judicial, if it's litigation that occurs, then the decision is either that there be paid to you as a right holder some compensation for the use of your rights, or you would have the ability to have the court force that there be no transaction, that there be compensation for the use of rights that have been infringed, and you'd have the ability to stop that use, to have the rights infringer cease and desist, or the rights infringer can continue if that rights infringer pays you a royalty for ongoing infringement of your rights. In a non-judicial determination, a non-litigated determination, there's the ability to reach a transaction where an arbitrator will determine that the rights have or have not been infringed, and if they have, then the ability to obtain for you in an arbitrated decision the compensation for the use of the rights, and in an arbitrated decision, which will be a binding decision, the ability to have the infringer stop the use of the rights. Or mediation is a situation where a mediator will listen to your side and will listen to the infringer's side of the argument and in some way reach some type of transaction that settles the dispute between you and the alleged rights infringer. It's also the truth that at a time of business has become global, but courts remain national. There is an increasing need to foster alternative dispute resolution to be less dependent upon variance in national regimes. I would submit to you that the American Arbitration Association, the international arbitration organizations such as WIPO, which provides for arbitration and mediation of intellectual property rights, either at Geneva, at The Hague, or there would be the ability to obtain the adjudication of rights under a WIPO tribunal, even conducted outside of Europe, outside of Geneva, that would give you the ability to obtain a WIPO recognized adjudication of a determination of your rights by either arbitration or mediation. And what WIPO seeks to do, what these international organizations seek to do, again, we return to the concept of harmonization, of standardization in the administration of rights and the determination of rights for infringement, the determination of the rights that the individuals have in their protection and enforcement of their patents and trademarks and copyrights, for example. The difficulty of the IP rights enforcement is that in many countries, enforcement is difficult for IP rights owners. Owners, for example, U.S. enforcement or enforcement by a U.S. citizen of a patent infringed in Korea, or a patent infringed in a Korean patent infringed in Korea, a U.S. citizen seeking justice for a Chinese business infringing an original U.S. patent that has been filed at the national stage and received as a Chinese patent. It's a difficult thing sometimes, and less so these days, but still a substantial hurdle for a U.S. citizen to achieve justice for intellectual property rights infringements outside the United States. The international system of litigation, of course, is yet to improve, particularly in intellectual property rights, because we're still in the process, as I hope the earlier modules made clear, we're still in the process of establishing intellectual property rights in many countries, in many first world countries as well. We're still in the process of establishing those rights, and part of establishing those rights is the enforcement of those rights. The enforcement of those rights is something that occurs after the establishment, after the, at least in some stages, will lag the establishment of the regulations of the laws that in fact create patents and copyrights and trademark rights. One way to obviate this difficulty is through arbitration and mediations. Well, courts are getting more and more involved in the matter, and there is some progress in sight. And so we'll talk about the concepts here of how courts have found it easier to listen to intellectual property rights matters, but there's still work to be done. For example, courts are listening to intellectual property disputes because there can be a lack of emotions. There's a lack of reliability. It is a complex system with complex problems. So that can be a challenge. The two speeds of justice akin to the medical field is the concept of need. For example, if in Rwanda there's the need to provide medicine to starving people, and a patent right is infringed by virtue of someone copying a medicine for administration to a people within Rwanda, just taking for example, an Rwandan court is going to be loath to exact penalties for patent right infringement. They may hear it, but the pace at which they go is going to be a lot slower when at the same time the people are being healed, people are being administered the drugs that are infringing the patent rights of the pharmaceutical company. And so there's some concerns about how that would work. At the same time, there is an explosion of trade, and a prerequisite to reliable trade is reliable laws for contracts, for intellectual property rights, for legal rights enforcement. And in order for trade to continue to grow, for people to invest in markets where they sell their technologies, there has to be a regime, there has to be a system of laws that will respect this, and the courts are the mechanisms by which these rights are protected. Now, arbitration and mediation has come, and I think will continue to come, to business people's rescue because of the reason that there's control over the process, and it's not over the outcome. It's over this control is over getting a decision, getting a reliable decision as to whether or not rights have been infringed and what the damages are relating to those rights. And there's a question of the efficiency of court proceedings in intellectual property disputes, not only in terms of the ability to get through the process, but the costs associated with such proceedings, the formalism, the rigor, the intellectual rigor that will be imposed by a court, by a judge, by jury, if the jury is called, delays in the court systems, and the basic complexity of intellectual property rights. Taking a jury, taking even a judge who is more concerned about domestic disputes or contract provisions through the anatomy of a patent document to determine whether or not the patent is valid, whether or not rights have been infringed in the patent, is a totally different it's an uphill battle to inform a judge or inform a jury as to the scope, the meaning, the importance of a patent, whereas, or a